Good evening. My name is Eric Silber. I'm honored to moderate this presentation tonight in my role as Vice Chair of the California Lawyers Association Committee on Civic Engagement and Outreach, as well as co-chair of the CLA Litigation Section Committee on Access to Justice and Civic Engagement, both of which are co-sponsoring this event tonight. I also want to thank the Beverly Hills Bar Association, which is also co-sponsoring this event. When I'm not doing civic engagement work, I'm an assistant United States attorney in Los Angeles, and I want to emphasize that the views expressed are my own and not those of the Department of Justice. I want to introduce our panel, which we're honored and privileged to have tonight, which consists of two Loyola Law School professors. First, Professor Laurie Levenson was a chief articles editor for the UCLA Law Review when she was in law school. She clerked for a circuit judge after graduating from law school, and she was an assistant United States attorney in Los Angeles for 8 years. She joined the faculty of Loyola Law School in 1989, and among other programs she's responsible for, she started the Fidler Institute of Criminal Justice. Professor Jessica Levenson clerked for a district judge after she graduated from Loyola Law School. She worked for a New York-based firm after that, and then she worked as the political reform director for the Senate Center for Governmental Studies. She joined the Loyola Law School faculty in 2009, first as an adjunct professor, and she focuses on election law and the political process. She's also a commentator on those areas, on television, on radio, and in print publications, and she does so frequently. She also hosts the podcast Passing Judgment, and she was the founder of Loyola Law School's Public Service Institute. As I said, we're lucky to have both speakers today. I want to give you, before we turn it over to them, I want to give you a brief roadmap of the presentation today. First, Professor Jessica Levenson is going to start with a discussion of the 25th Amendment. Then Professor Laurie Levenson will lead a discussion of impeachment. And then Professor Jessica Levenson will lead a discussion of the 14th Amendment. After that, they will both field questions. As you notice on your screen, there's a Q&A button on the top of the screen, and you can submit your questions in that, using that button, and I'll monitor it as we're going along. With that, I'll turn it over to Professor Jessica Levenson to talk about the 25th Amendment.
All right. Thank you, Eric, so much. And thank you for asking me to be part of this. And I am well aware that I am the person who stands in between you and the person you really want to hear from, Laurie Levenson. And so I'm going to be brief. I am the sandwich, and I'm going to talk about, frankly, the roads not taken. So I'm going to talk about the 25th Amendment and specifically how you can remove a president who doesn't really want to go. And then I'm going to talk about the 14th Amendment and how maybe possibly you can remove a president who might support something hypothetically like an insurrection. I also know what you're all thinking. I didn't actually buy the scarf myself. My co-panelists got this for me. It was a birthday gift, and I wear it every chance I can. And thank you for letting me do this with you, Professor Levenson. I met my husband in her class, and yet we're still friends and we still do these things. So I appreciate that. All right, 25th Amendment, without further ado. What happened? Why do we have the 25th Amendment? In really simple terms, we basically understood that we didn't have a good secession plan. We didn't have a good plan for what happens if the president is ill, what happens if the president can no longer serve. And this really was kind of facilitated, or it began as a result of President John F. Kennedy's assassination. And we needed to solidify what these plans were. Now, there's a number of different sections for the 25th Amendment, and those are used. For instance, a president who voluntarily goes under anesthesia. The most kind of typical example is a colonoscopy. You have one letter that says, I'm going under anesthesia, Vice President, have a good time. Please, try not to drive the car too quickly. And then you have another letter that says, I'm feeling great, I'm back, and the anesthesia is done. Now, when it came to President Trump, we started talking more about a section that we've never used before, and that's a section for involuntarily removing a president. That's the section for a president who doesn't say, you know what, I'm not okay, or who doesn't say, I really need somebody to step in for a little bit or for the rest of the term. So the 25th Amendment, Section 4, again, we've never used it. It does have some standards. I'm going to talk really briefly about what you would do. Step one would be that the vice president and a majority of the cabinet, or the language is such other body as Congress may by law provide, which basically means if Congress wants to create another legislative body that the vice president would talk to, that the vice president says to the president pro tem of the Senate and the Speaker of the House, the president's not okay. And the standard here is the president is unable to discharge the powers and duties of his office. Now, what we should notice here is that all roads lead through the vice president of the United States. And the drafters of the 25th Amendment decided that the vice president was essentially the person best entrusted to make this decision. But we now all know from having lived through many questions over the last 4 years that that's an enormous amount of power to give to one person. Again, Congress can't trigger this. The cabinet alone can't trigger this. You always have to have the buy-in from the vice president. Vanna White, could I please have the next slide? All right, so step number one, the vice president and a majority of the 16-member cabinet or a majority of some other legislative body that Congress has created says the president is unable to fulfill the powers and duties of his office. At that point, the president can say, you know what, I'm just fine. And this is where things, if you didn't think things were messy before, this is where things get even a little bit messier. He can say to the president pro tem and the Speaker of the House, don't use this, don't invoke this. I plan to stay in power. And at that point, what it triggers is a vote by both houses of Congress. And Congress, if they're out of session, I think they have 48 hours to come back in session. If they're already in session, then they have 21 days from that moment. In either case, 21 days, either from coming back in session or just from the moment you get it, if you're in session, to take a vote. During that time, I think the better reading of the amendment is that the vice president is in charge. So during that time, Congress is voting, and you would need 2/3, you need a supermajority of both houses to agree with the vice president that the president is in fact unfit. Now, if either side is not happy with the outcome, this can continue to play out. And you can, for instance, the vice president and a majority of the cabinet could say, no, Congress, you got it wrong. This guy is really not okay. And you can try and force a vote again and again. Now, I think this brings us to the next slide. A couple of questions, things to think about when it comes to the 25th Amendment. We don't have a great standard for what unable to discharge the powers and duties of your office means. It will not surprise anybody on who's watching right now, because you're all lawyers, to know, this isn't a bright line standard. The people who wrote the 25th Amendment thought about giving examples, thought about giving a non-exclusive list, but they didn't do that. And so it can be open to more discretion, open to more interpretation, which of course can be a good and bad thing. We also don't know exactly what the vice president and a majority of the cabinet or a supermajority of Congress should look to. We know that nobody intended this to be triggered by a policy disagreement. Nobody intended this to be triggered by, we just don't agree with their views on tax policy, environmental policy, that it really has to be something much more egregious and outside the norms of acceptable behavior. But we don't have a list of factors. And also notice who's making the decision here. Who's making the decisions? Political actors, people who are chosen by the president, people who might be very loyal to the president. That, again, that's by design. But of course, we don't have medical professionals, we don't have psychiatric professionals. So one of the questions is, would there be people who are better suited to make this determination? Now, Congress could try and pass a statute providing a little bit more guidance or feedback to what we mean. I suspect that won't happen. And, in closing, my hope is that we don't have to use the 25th Amendment in the future. We have now seen, I think, how very difficult it is in order for it to be used in real life. So now, again, that's the first path not taken. I think with that, I'm going to get to the main attraction. Professor Laurie Levenson, I believe it's impeachment time.
So much impeachment, so little time. Thank you, Eric, so much for inviting me to participate, especially with my brilliant colleague and former student, the real Professor Levenson, the smarter, the younger, the prettier. Okay, that's enough. Let's go on to impeachment, everybody. So when you were last perusing the Constitution, you were probably looking at some of the articles I have up on the screen right here. And they lay out how impeachment is supposed to work, at least in broad terms. The House actually brings the articles of impeachment, although you note it doesn't say how it has to do that, what type of committee work has to be done. Then the Senate actually has the trial, and it has the power to try the impeachment. Now, ordinarily, the Chief Justice presides if the president is being impeached. But you've probably all heard that they're going to use Senator Leahy this year because, in fact, Trump is no longer the president. So now we go back to the standard of using the president pro tem of the Senate to go ahead and preside over it. We'll talk about the limited powers he really has in that position. You'll need 2/3 of the senators for a conviction, which means in this particular case, with the split in the Senate, you would need 17 Republicans voting to convict. Probably unlikely, particularly even in light of the vote today, where they tried to stop the impeachment trial, and you only had Senate, you had 55 to 45, not likely to happen. And then if there is in the trial a conviction, there is the power to remove the president. And what we'll focus on a little later on is really the power to stop that individual from taking federal office again. Article 2, Section 2 talks about presidential powers in general, that there's no pardon power in an impeachment case. And then Article 2, Section 4, what can you be impeached for? Treason, bribery, or quote, other crimes and misdemeanors. And we've probably all learned from prior impeachments, that's not that it necessarily adds up to a criminal conviction for a specific provision. All sorts of things, including abuse of power, could constitute a high crime and misdemeanor. So a little bit on the history here. We've actually had 3 presidents have been impeached: Andrew Johnson, Bill Clinton, and Donald Trump, but none of them have been actually convicted. Now you're all saying, what about Nixon? Well, he came on the verge of actually being impeached, but he actually resigned, and then he was pardoned by Gerald Ford. There have been no presidents that have actually been convicted by the Senate. And we've actually never had another situation where we're impeaching a president after leaving office, although there have been situations where other members of government were impeached even after they tried to resign. So a little bit about the process of impeachment. As we mentioned, the House starts the ball rolling, and then the Senate holds the impeachment trial. Eric asked me to talk a little bit about what's supposed to happen in the House, and did it happen this time? Well, if we look historically, in the Nixon case, there were months of hearings by the House Judiciary Committee, even though there were no formal impeachment that occurred. Clinton, there was a grand jury investigation and the Starr report. Trump 1, as I call it, was the Mueller investigation, a grand jury investigation, a big report, and hearings. And now we got Trump 2. And basically the House had a couple of hours of speeches. Does that qualify? Why not? They get to set their own rules. And I don't think any court, including the Supreme Court, would interfere in this because it's a separate branch of government. And under the Constitution, they set their rules. So how are the charges this time different? Well, the drafted articles of impeachment for Nixon actually talked about things that may sound familiar: obstruction of justice, abuse of power, contempt of Congress. But there was no violence there. You did not have rioters storming the Capitol. You didn't have people die. The Clinton impeachment, he lied, not a good thing, to a grand jury and in a deposition about sexual misconduct. Lying is not good, but nobody is storming the Capitol. Nobody is dying. He did obstruct justice by encouraging Lewinsky to lie, but categorically different. Even Trump 1 was a different type of impeachment. It alleged abuse of power when it came to dealing with the Ukraine and withholding monies in exchange for their help. Obstruction of Congress is laid out in the Mueller report, where he's not exonerated. You just have Mueller saying that he doesn't think that this is the basis for a criminal action at this time. And we had, in fact, no Republican crossovers in support of the impeachment. But now we get to current events, which is Trump 2. And there is only one article in the impeachment packet, but it is jam-packed. It refers to something that Jessica Levinson will talk about in a little bit, which is the 14th Amendment, and a section in that talks about if people have been engaged in insurrection, how they should not be able to hold office, clearly anticipating what they're trying to get out of this impeachment. And it spells out that there was interference with the counting of electoral votes, the actions of Congress. They talk about that Trump made false claims about the vote. They use language of subvert and obstruct certification. They make reference to calls even to Raffensperger. You remember that call, "Can't you find me some more votes in Georgia?" And phrases like endangering the security of the United States, threatening the integrity of the democratic system, interfering with the peaceful transmission of power, and imperiling a co-equal branch of government. And this one did have 10 Republican crossovers. So why is this impeachment different? Before I move the slide, just look at the images. The picture tells the story. This was America on the brink of something that I would think that most of us thought we would never see. People storming the Capitol. If you've been there, you know how almost a holy place it is. Someone dressed like that gentleman on the bottom there, sitting in the chair of the person who presides over the Senate. This was categorically different. So the nature of the charges are different. An allegation of insurrection that goes to the heart of what's supposed to be peaceful transfer of government. People died and there was an attack on government. What else is different? I would suggest that the available evidence is different. You have videos, you have photographs, you have rioters coming forward to say, "Let me tell you why I think the president made me do this." And we have an explanation for why the House action wasn't a lengthy study by a committee, the need for quick action and deterrence. So the focus has to be not just that there was a riot on the Capitol, but frankly on Trump's actual role. And that they've spread out into 3 different categories. His speeches on the day of the riot, his prior conduct in claims, which they would say was used to incite, and his unwillingness to help once the riot started. So I know a lot of people are focusing on, can just his words at the rally be enough? They're not focusing on just the words at the rally. They realize that there are protections under Brandenburg in the First Amendment. They're asking for folks to look at it in context. If you ask whether those things are high crimes and misdemeanors, well, We do have in the federal code an incitement of insurrection. It is a specific crime, although they don't have to prove it the way you would have to prove it in a court of law. We also have provisions seeking to overthrow the government. And the argument can be made, this is a branch of the government. So again, I actually don't think the hard issue in this impeachment is whether it's an impeachable offense. It's a separate issue of whether they will make the case to the extent that a political decision is made, because a Senate trial is not a judicial decision. It's a political decision to convict the president for those actions. Again, what makes this different? Well, what makes it different is that the people who are going to be deciding the case were affected by the case. These are images, of course, of legislators while the chambers are being stormed. And the idea of, are we going to call witnesses? Many of them were terrified witnesses to what occurred. And if those images aren't enough, take a look at some of these and ask yourself, does this rise to the level where it's unexpected that you would see an impeachment charge? Now, as time goes by, people will say, oh, can't we just make peace with it? These images are not going away, nor are these images, right? And that's a Capitol police officer basically screaming for his life. Those are gallows where they have communications that said they were going to be used for Pence and maybe Pelosi. And then you have this fellow who has the ties and the explanation that those were going to be used to grab legislators and put them into harm. What do I expect to happen in the Senate impeachment trial? Well, the trial happens in the chambers of the Senate, the very same place where you had these actions, and a little basics on a Senate trial. The Senate sits as the jury, but not the kind of jury that we're used to, where you have a judge who gives the instruction and the jury makes limited findings. This jury decides yay or nay on the conviction, and you need 2/3. Now, once you have 2/3 voting for conviction, then it's only a 51%, it's only a majority to get removal and to prevent the president from future office. And that's probably the goal here. Now, again, ordinarily Chief Justice presides, but that's not happening. Leahy's going to preside. And you might say, well, what does he do? He decides evidentiary objections, but not according to the evidence code. And I'll show you that. The Senate can decide what rules of evidence they use. It's all in their park. And he can be overruled, Leahy, by a simple majority, although right now it's the Democrats who have the majority in the Senate. The prosecutors are not called assistant United States attorneys, although many of them were. They're called House managers. Adam Schiff was a House manager in Trump 1. And the president can have representatives, as we think of as defense counsel. So, talk about the key rules of what's going to happen in this impeachment trial. Timing seems to be everything, and they're supposed to start at 12:30 promptly. They've already sent over the article, sworn everyone in, and taken sort of 2 weeks to do the business of Congress, get cabinet members confirmed, and get the briefs written. The type of trial depends on the Senate. It's supposed to be open proceedings, but it could be closed. I get the question, could they compel witnesses? Probably. We don't know. Let's not forget, nobody seemed to want witnesses on the Republican side during Trump 1. They basically just wanted to read in and argue on the record what had been handled in the House hearings. What about the Fifth Amendment? Well, I'll talk about that, but yeah, perhaps they could get immunity for their testimony. You can always assert the Fifth. There's usually one opening per side, but the closing arguments can often have 2 people. Only if you had a witness, 1 person at a time. You've all heard this from judges if you've been in front of them. And senators can actually object. Now you're saying on what basis? Whatever the Senate allows. And they argue those objections. There are 51 votes for a quick dismissal. We now know that that's not likely to happen. That's kind of what they tried today when they said that, in fact, it wouldn't be constitutional to even have the trial because Trump is no longer the president. But that's one possibility. I think so. The fight today is about whether the American public would really see what happened. It would take 67 votes to convict and remove, but only 51 to prevent from future office. So, some interesting questions. Can a president be impeached after he's left office? Well, we've never had that decided before. We've never done that with regard to a president. But Secretary of War William Belknap tried to avoid impeachment by resigning, and too bad, they impeached him anyways. So there are arguments on both sides. Jonathan Turley has said, no, he doesn't think a president can be impeached once he's left office. But the counter argument is, one, they actually returned the article of impeachment before he left. And second of all, logically, wouldn't that give allowance to a president to do whatever he wants in the last days of his presidency with no recourse? And finally, if you look at the sanctions for doing so, it's not just being removed from office. It's also being prevented from serving office in the future. So those are the arguments, and politically, they're moving forward, saying that you can do it. The question that often comes up is, well, but what purpose would it serve? I think that disqualification to hold any office. But let me ask Jessica, just to let her in here, do you think even if they lose this trial, there's a good reason to have it anyways? Unmute.
My God, I was just so, right before we went on, I was like, I'm never that person. I'm always remember to unmute. I think there is a purpose in holding the trial because even if, look, removal's off the table, right? Because the president's term has expired. Even if you can't disqualify, I think there's a purpose because constitutional provisions are there for a reason, and you're supposed to use them even if it's not politically expedient, even if it's not convenient, even if the timing isn't great. And I also think it sends a message that it allows a number of our representatives to go on record and say, this is not appropriate behavior, and we have a constitutional mechanism for that. And we didn't skirt our constitutional duty just because we didn't think that the outcome was going to go, quote unquote, our way. Professor Levinson?
Thank you, Professor Levinson. I think that's exactly right. And for the Republicans who are not inclined to convict, that's why they're going to fall onto the procedural argument. I think this is terrible what he did, but I don't think that this is the procedural mechanism. So when will trial begin? They're busy filing their briefs. That's sort of the roadmap for what's going to happen. The House managers' briefs are due February 2nd. The Trump's team is due February 8th. And I think we probably, mark it on your calendar, can expect the opening statements on February 9th. But we still don't know, frankly, what this trial will look at. I will hazard a guess in just a slide or two. As I mentioned before, I think everyone agreed to the timing given the pressing needs for the COVID bill, confirmation of cabinet members, and this is to the advantage of the Democrats in seeking this, because every day new evidence is coming out. Every day the FBI is apprehending new people, getting new social media posts, being analyzed, new evidence. And so getting the 2 week is like getting 2 more weeks of investigation. So what will the trial look like? Will it be just arguments or witnesses too? We don't know what it will be like. I think that the prosecution, the Democrats, can present a really compelling picture, literally story, to the American public without witnesses, right? First of all, they have all that video. Second of all, the lawmakers themselves are saying, why do you need witnesses? We were there. We don't need witnesses. And then finally, it is clumsy to say the least, whether there's a Fifth Amendment. Do I think the president is likely to testify? You know, I rather kind of doubt it. I don't think Trump is always his best asset in when he speaks extemporaneously. And so I think that that might be a problem, but we can see. Some other questions in your mind? Rules of evidence don't apply. They can use all the hearsay they want. I teach evidence. I'd wish that they had to follow the rules of evidence. They don't. It can compel witnesses, but the Fifth Amendment still applies. Burden of proof is not beyond reasonable doubt. It's what the Senate wants it to be. How much evidence do they need? When Leahy is presiding, he will not give instructions on the law. That's not part of his job. And the deliberations are the one part that are not public. Now, they're not supposed to go out in the hallway. They're not supposed to chat about this informally. They stay in the chambers, and the votes are public, but not the deliberations. So welcome to who's going to be doing all this. The House managers for this proceeding are going to be led by Jamie Raskin, whom you probably know has had recent tragedy in his life. And he was in the chambers when this all happened. He lost his son on New Year's Eve, and joined by other representatives, many of whom have frankly served as prosecutors. The defense will be led by Butch Bowers. You might remember Butch Bowers from representing Governor Mark Sanford when he said that he got lost in Argentina or whatever, but in fact, he was having a bit of an affair and he was being impeached by the South Carolina House, and he was represented by a very able lawyer, Butch Bowers. I understand today they brought on Deborah Barbier. Barbier. She also is the South Carolina defense lawyer who is a former AUSA. And so this may not be their whole team, but they're off and running. Take a look at who's not the lawyers on these cases. Rudy is not a lawyer. Rudy may very well face other consequences because he was giving speeches at the rally. Jay Sekulow, who represented Trump in the first impeachment, Alan Dershowitz, Pat Cipollone, nobody's there, nor do I know if anybody who will be there will ever get paid. Okay, now the likely prosecution arguments. Trump's purpose was to undermine the election. And you can know that from everything he said and did, not just on that day. That when it came to the inflammatory remarks, sure, you know, you'll never take back our country with weakness. You must show strength. In the abstract, one could argue that's just saying, really be committed to your values, not enough to incite, which is why they have to put it in context, including remarks by people who were up there with him, Giuliani, who said trial by combat. And then you add to it, he did not take steps to stop the rioters. Instead, he said, we love you, you're very special. So I expect that there will be a timeline. And while the rioting's going on, you're going to see pictures of Trump sitting in front of the TV and having a Diet Coke. And it's that imagery that makes this of value for the American public to see. There is additional evidence every day that comes out. I mentioned that the rioters are happy to give up the president. He made him do it. There's an inside investigation of whether there are people helping in the Capitol, social media, videos posted, all of the above. Let me quickly finish this up then. The defense arguments are whatever the defense is always going to be what it needs to be, folks. We know that, right? And the best argument here is this is an unlawful process. There cannot be this impeachment once he's out of office. And so procedurally, it's wrong. We're not giving our blessings to what Trump did, but let him go on his way and not use this constitutional process. In addition to this, I think the defense lawyers will capably argue there was no intent for insurrection, that Trump is careless, to say the least, reckless in how he uses words. And he gets worked up and he says, go fight, you know, be strong. But no one ever really takes that seriously to mean do violence. And that we have the standard under Vandenberg versus Ohio 1969, that there has to be incitement to imminent lawless action. And that's belied by his remarks like, you know, we love you, just go home, that he saw this as a political rally, okay? And that he had a right to challenge the election. Even though 62, at least, decisions by federal courts, maybe more, had told him, you lost. And it was a fair election, we don't criminalize people for using a process to challenge the election. The last thing before I send it back to Jessica is this: will there be a conviction? Well, ask these folks, right? Because they decide, and they're going to decide more probably on political reasons. If Trump is convicted, there will have to be a separate vote to determine whether he's barred from future office. And there are the open questions, whether there would be any criminal prosecution. How does he challenge this impeachment? He's tried to have the Republicans do it for him, but I don't think he has a mechanism to run to a court. The Supreme Court ain't touching this. Roberts is not touching this at all. And so the courts won't interfere. So with that said, Professor Levinson, can you talk a little bit about our last topic before we open it up for questions, the 14th Amendment?
I'm muted again. That was so great. I mean, this is why you're going to kill me for saying this, but this is why your students are so lucky. And this is why whenever I see you on TV or I hear you on the radio, it's so clear. It's just
Q&A again. An A.
No, you didn't.
Highest grade in the class. There you go.
That was one of the lowest grades. That evidence class was one of the lowest grades I ever got in law school. But we'll talk about it at next year's Seder. So here's the other kind of road, potentially not taken, the road that maybe we'll take, the road that we rarely have thought about taking. And that is the 14th Amendment. So the basic warning here, and I'm sorry, I'm just calling up some notes I have for myself, because this is not something that I typically teach. We don't really talk about Section 3 of the 14th Amendment all that much. So the basic warning from Section 3 of the 14th Amendment is if you're a senator or a member of Congress or somebody else who holds a public office, this could include the president, don't engage in an insurrection or a rebellion, and don't give aid or comfort to people who do. Now that feels fairly straightforward, but there's a lot of issues in terms of the mechanism of how you raise this and how you would, for instance, expel either a president or a member of Congress. So a little bit of background first. The 14th Amendment, oh, thank you. You read my mind. When we do the 8 p.m. show, this will be totally seamless.
There you go.
So the 14th Amendment, ratified in 1868 in the wake of the Civil War, famously known for providing citizenship and equal protection under the law to anyone born or naturalized in the United States, including formerly enslaved and free Black people. This provision, Section 3, is aimed at Confederates following the Civil War, seeking to bar them from holding office during Reconstruction. And that's when it was frankly used in all but one case. And Section 3 was used not to expel people who were already in Congress, but to say, we're not going to seat you, to say that we're going to prevent former members of the Confederacy from gaining a position in the House of Representatives. So again, that is actually quite different to say you don't get to be seated as opposed to you're a sitting member of Congress and we're going to expel you. And I'll talk a little bit more about that in a minute. So Section 3, again, invoked since the Confederacy one time. In 1919, Congress barred Victor Barger, a socialist from Wisconsin, from occupying a seat, again, telling somebody you don't get to be seated after he was opposed to the United States entering World War I. But all of the other situations dealt with saying we're not going to seat former members of the Confederacy. Now, after January 6th, after the insurrection in the Capitol, people started bringing up Section 3, both, again, with respect to the president and members of Congress who might have provided aid or comfort to those who engaged in the insurrection. Now, I think that the best answer here is that if we were to go back in time, and now it's only, 7 days, but during the Trump administration, that ending the Trump presidency under the 14th Amendment would have been all but impossible because there isn't a mechanism for removal. There's no removal provision. Now, there are certainly people who disagree. Again, and I've said this to my students so many times over the last 4 years, but we don't have a case on this because we've never tried to do this before. And this is true for self-pardon. This is true when it comes to Section 4 of the 25th Amendment, as we talked about, and this is true for Section 3 of the 14th. We've never tried to use it this way. But Section 3 of the 14th Amendment could be used to try and prevent Trump or other politicians who, again, might have given aid or comfort in the insurrection from holding office again. So it would be similar to what Professor Levinson talked about for the impeachment. If there is a conviction by 2/3 and then a separate vote by a simple majority to say you're disqualified from holding office again, you could have the same endpoint, the same effect by trying to use Section 3 of the 14th. Now, it does not require an initial supermajority vote, which I think is why it was appealing to a lot of people. You don't have to go through a whole impeachment process. And it wouldn't kind of take up all of the oxygen in the room in the beginning of President Biden's administration. So what you would probably need is a majority vote in Congress that says lawmakers think that Section 3 of the 14th Amendment applies, either to the president or to other members of Congress or both. And then the courts would likely have to become involved, make a declaration that determines that this means if they do try and run for office again, they will not be seated. So there's a lot of unanswered questions here. I think that is basically the best answers we have so far. Now, the second bullet point on the slide is Congress has sole authority in terms of expelling or punishing members of their own members. So there's basically two punishments that you can give to members of the Senate or members of the House. You can censure them, which is basically saying, we really don't like what you did, and we're going to put it on record because we don't like it so much. The other is to expel them. If members of the House tried to expel current colleagues who they think helped give aid to the people who engaged in the insurrection, that would take a 2/3 vote. And I think that there is no political appetite for this. Members of the House, members of the Senate tend really not to like to expel their colleagues because they don't want this suddenly to be used as a sword against them, for instance, if they just become politically unpopular. So I used a lot of words to say Section 3 of the 14th Amendment has never been used in this situation, could potentially be used to prevent President Trump from, if he's elected again, from being inaugurated, could potentially be used against members of Congress. And I suspect that everything Professor Levinson talked about is what we're actually going to do, and that we're not going to use the 14th Amendment. And
thank you to Professor Levinson, and thank you to all of you for listening in, but we'd really like to answer your questions the best we can, keeping in mind this, folks. We've said several times, it's never done before. So we're making our best educated guess to tell you what the arguments will be on both sides and what will happen. And that can change day by day. I think up to this point, Biden has wanted to stay out of it. He has said he thinks that Congress can walk and chew gum at the same time and can get their work done. But again, we don't know exactly what it will be. There does seem to be a strong appetite for the Democrats to create a historical record as to what Trump did. Because even if there's not a formal vote to keep him out, that loop, that tape, that presentation is their best ammunition against him coming back. It might be the best fodder for his base, but for the rest of America to remind them what is at stake if he does run for office again. Eric, with that, we turn it over to you.
Thank you. Let me run through some of the questions we had, and I may add in some questions of my own that I have as well. We had, is a 2/3 vote of in the Senate, is that of all senators or is it of the senators present? So for example, if some of the Republican senators boycotted the vote, could the Democrats with very few Republican senators actually convict?
Jessica, I may be wrong, but I think it's those present. So boycotting would actually lower the numbers needed for the conviction of the president, which is why I think you're not likely to see the boycott. Instead, I think you're likely to see what we saw today, which is we're here under protest. Jessica?
Yeah, I think that's exactly right. There was a good article written about this in late 2019, I think, by Lawrence Tribe, and he pointed out this exact issue, which is that it's most likely present.
Now, another question we've got on kind of the procedure in the Senate is a conviction a prerequisite to the Senate voting on a bar to future office? Could the Senate just skip to the remedy and not actually convict the president, particularly in this circumstance where he's not currently in office?
I think for the impeachment process, you need the conviction and then the question what the sanction is. What Jessica offered up is that if you go by the 14th Amendment, then you don't, which is why I think they're going on multiple tracks.
And could you see, let's assume for a moment that there is no conviction in the Senate. Could someone make a motion at that point to have Section 3 of the 14th Amendment bar the president from running and for future office and the Senate vote on it, and that having some consequence for future elected office for President Trump?
Jessica?
You could. I mean, again, I would echo what Lori said. I think that's why they're taking two tracks here. I think, as I mentioned, that you probably still need a legal declaration. But yes, that's what you would take. It would be a majority, not a 2/3 vote.
Now, does the fact that the House cited Section 3 of the 14th Amendment in the Articles of Impeachment, does that do anything to an argument later on that the president is barred without any further finding from the Senate? Could someone rely on that to say the Article of Impeachment cites this, therefore the president is barred?
You know, I've been thinking about this and I'm wondering what the other Professor Levinson thinks, but you know, it does strike me that once you have the conviction on how this article of impeachment is written, you've got sort of collateral estoppel for the issue of whether the 14th Amendment applies. If you put it right into the charge, it seems to me it's like a forfeiture provision. In an indictment, it applies.
I defer to the one of us who actually practice law. I agree with that.
Well, I guess another related question is, and I don't suspect this will be done, but what if President Biden issued an executive order saying that Section 3 of the 14th Amendment applied here? Could that have any effect on future elected office? In other words, do these various references to Section 3 of the 14th Amendment do anything in and of themselves?
I don't think so. I mean, I think we're already going to see, I'm sorry if I stepped over you. I think we're already going to see executive orders kind of stretch to the max in terms of how often and in how many circumstances they can be used. I don't think that alone would trigger any specific consequence. But Professor Levinson? Yeah,
I don't think that, frankly, the 14th Amendment, by the history that Professor Jessica Levinson presented, envisions that determination of insurrection is made by the executive. All of this seems to be much more focused in Congress and whatever votes that Congress will make. So I don't think that Biden would frankly be eager to do it. And second of all, I think that given the history of it, it's more likely to be Congress. Jessica?
I totally agree with that. I don't think there's a mechanism for whoever's the chief executive basically waving a magic wand and saying, I think it applies.
Now, Professor Lori Levinson, when you were talking about kind of the evidence that would be presented at the impeachment trial, you mentioned President Trump's reaction to the riots at the Capitol. And we had a question about what evidence there could be of that. So could the Senate call in the Secret Service as witnesses? Could they call in the ushers? Would maybe the White House photographer took some photos of that at the time? I mean, how would they prove the reaction? What are the available tools to the Senate in getting that evidence?
I think all of the above. I think, frankly, they could call in family members if they wanted to be on board to have them there and make people uncomfortable. And I know the president sort of would feel that, gee, this is really private. And you might even hear him, because he has cavalierly referred to executive privilege in all sorts of situations. But I don't think that would hold up at all. First of all, the Supreme Court has made it clear, even in the legal situation, it's not an absolute privilege. And those are the people who actually witnessed. I don't know. I've never been in the private quarters of the White House, whether there are videos, whether there are tapes. But I think everybody there is possible to be a possible witness. Now, keep in mind, as the managers, you got to be careful. You're calling, quote, hostile witnesses. And so those people might go out of their way to support, how the president looked in their eyes. So, Eric, you and I always know, don't call a witness where you don't know what they're going to say or how they're going to react. Less can be more. And if they can get one person who can really make that description, or the president himself who admits what he was doing during that time.
What happens if there's a dispute on this? Let's say the president invokes an executive privilege of some kind, and the Senator Leahy overrules it. Is there an ability of the president to go to court and try to get relief, or does he simply have to continue with the proceedings at that point?
I don't know if Jessica would disagree, but I feel that no, there's nowhere else to go. The Senate itself is going to decide its evidentiary rules, and there's no court that's going to come in and say, no, we want you to use these instead. So they have to work it out, and it may come to a stalemate, Eric, honestly, where they just sort of say, we don't have the right evidence, and that's the reason we're not going to convict. I think people are sort of piping in a lot of exit routes without saying we agree with what Trump did.
If the Senate deadlocks 50-50 on a procedural vote or an evidentiary type vote, does the vice president get to break the tie in the impeachment proceedings?
In this particular proceeding, the person presiding would be Leahy, and he's going to make those determinations. Jessica?
Yeah, I don't, you know what? I don't know the answer to that question.
I'm not sure, the vice president usually decides on a split vote in the Senate, but this is a totally different type of proceeding than a legislative proceeding.
Yeah, I'm sorry, I don't know the answer to that question.
And a question on the 25th Amendment, ultimately, which wasn't used here, but it requires a 2/3 vote by both houses, and it doesn't seem, if the president asserts that he is capable of proceeding, and it doesn't seem like those votes were here for at least the speaker in the House, and possibly not the Senate. Was the design here to wait out the 21 days and never have the vote and keep the vice president acting as president? Because you mentioned there's a 21-day period to vote on returning the president to power.
So I think that was, by the time we started talking about it again on January 6th and after, I think that was the political strategy, which is the way I read the 25th, that when the vice president and either a majority of the cabinet or a majority of this other legislative body says to the president pro tem and the speaker of the House, he's not okay, and he delivers that in writing, that triggers the vice president taking over while that vote occurs. And so that, I think this was your question, that the play essentially is then the vice president will be in charge while Congress kind of drags its feet, because at that point, there were only 13 or 14 more days in the administration.
And I would say that they invoked what I would call the informal 25th Amendment. When Nancy Pelosi is going to people in the Pentagon and saying, please don't let him push the buttons, where they're sending him off to golf instead of being in the White House, where they're doing sort of just damage control, where Mike Pence is showing up and Trump is allowed to sort of fume and rile up his base. That's an informal way of saying he's not the one in charge, but it's I think we don't know the whole story yet, frankly, folks. When we find out exactly what were Trump's thought processes during this, let's think a moment about what kind of lawyer let him make those calls to the secretary in Georgia. That seemed to me, just listening, and I listen, you can read the transcript of what he said, that there were lots of issues, cognitive issues that seemed to be amiss at that point.
We had a question about whether Senator Leahy gets to both rule as the presiding member as pro tem, and then gets to vote on whatever the issue is. So for example, if he rules on something and 50 Republican senators vote to overturn it, and there's only 49 Democratic senators because Leahy can't vote, do the Republicans win, or does Senator Leahy get to vote then on whatever the issue is, so that it's potentially a tie at that point? I mean, does he get to vote and rule, or is it one or the other?
Jessica, do you have a firm answer on this?
I think the answer is that he gets to vote and rule, but I'm going off of my memory of the old Senate rules of procedure of impeachment. Please feel free to publicly say your memory is failing.
No, yeah, I'm going to publicly say that that actually makes sense to me, because when you use someone like him as opposed to the Chief Justice, that's one of the aspects of using the Senate pro tem to preside, is that he doesn't stop becoming a senator during the process. But I wouldn't swear on it because I'm not that sure.
I had another question about Section 3 of the 14th Amendment. Let's assume that there was a criminal trial of the president from this, and he was acquitted at that criminal trial. Could he hold up the acquittal to say he's not barred from running for future office were someone to assert it? Or does the different standard of proof or the different type of proceeding mean it wouldn't have much impact on a future run for office?
So, Eric, I'm sorry if I misunderstood, but is the question basically he's tried for incitement of insurrection in federal court, he's acquitted. Would that have an impact on, would that be his kind of get out of jail free card for you don't get to use Section 3 of the 14th Amendment to bar me from being seated or inaugurated?
Exactly. So he would say, I was acquitted of this, therefore Section 3 of the 14th Amendment isn't a bar, therefore I can run for office in the future.
Yeah, I mean, my answer would be that that's a different standard. That's in a courtroom versus in a political body, that those two things are just parallel tracks. And you're using similar words like insurrection and incitement, but that they're totally separate.
I agree with that. And I think we even have the model, as we all know, that you can have somebody who's acquitted in a criminal case and still face civil consequences,
Right.
Even more so with political consequences. So I don't know of anything in the law, the Constitution itself, that would say that that acquittal would be, a bar to using the 14th Amendment.
Well, I think we're out of time at this point. I would like to thank both Professor Levinson for this wonderful discussion that we had today. We really appreciate you taking the time to talk to us about this. And as I said, it was a very helpful discussion. So thank you very much.
It's my pleasure. If I may say one thing in addition to thank you to you and to Professor Jessica Levinson, I want to thank everybody who's watching. And I respect the fact that people are paying attention and that you have your own thoughts. This is an evolving area of the law. In that way, it's really exciting, not just academically, but how it affects all of us. As lawyers, we're used to having the answers to everything. And then when you get into this part of the process, it morphs. And so this is making history. This is making literally the precedent. If, God forbid, we have to do this in the future, it is a little alarming how quickly we're facing issues of impeachment again, but this is a way of testing what kind of mechanisms we have in our Constitution to deal with disruptive moments. And this impeachment is categorically different, folks. People died. They attacked the Capitol. And that's not something that I think that people will forget quickly. So thank you so much. And if you have additional things you want to bring to my attention, just contact me through Loyola Law School. You got my email, and I'd be happy to hear from you. Thanks again.